Yes. And,
Okay.
we'll get on to the time frame and everything.
Sure.
And we got down here at the bottom, that if the plaintiff expert testimony, if we don't have one, or it gets cut or in any way limited, it can be a backdoor summary judgment. In other words, they can knock out your causation argument or knock out your damages argument if it's not complete.
Okay.
And we kind of refer to that as a backdoor summary judgment. And good defense lawyers are going to do this to you.
It usually, from a plaintiff's area of expertise, or from a plaintiff's view, this is something that they should be prepared for. You practice predominantly as a plaintiff, correct? As a plaintiff's counsel, correct?
Yes, 100% plaintiff's work.
100% plaintiff's work. So this is something that you have to go into the discovery portion, or into the beginning of this case with this in mind, that they're going to try and knock out your expert.
Absolutely, absolutely, and that's why we say it's the most important rule. It's the most important part of your entire case.
Okay, all right. And you just let me know when you want me to move on the slides, Daryl.
Okay, I think we're good on that one. Just basically saying without that, there's no case, and that's why we feel like it's so important.
And this, just for maybe some clarity for myself and others, Daryl, it won't be at the disclosure date. Would it necessarily be at the disclosure date where defense would then try and get rid of plaintiff's expert, or does that come in a later motion?
Yeah, that comes later, and it comes in the form of Dobbert challenges. It comes in the form of summary judgment.
Gotcha.
So yeah, that comes a little bit later.
Gotcha. Okay. All right. You should have the next slide up.
Yeah, this is a pretty fundamental for those of you who do only under the federal rules and whatnot, is that experts must provide a report in federal court. The only way they cannot is if they get an agreement or an order from the judge, which I don't encounter that very often. So, general rule of thumb, we must have a report for federal cases. Some states mirror that record. My home state of Kentucky does not. We just have to disclose, and as a plaintiff's attorney, I like to disclose in great detail, our experts prior to the disclosure deadline. Now, many times in Kentucky State Court, we will follow up with a report, but we don't have to.
Right.
And under the federal civil rules, you do have to have a report. It has to be signed and dated by the witness.
And you made this clear in our preparations for this. You had made clear that it has to be signed. It can't be some sort of initial report or something like that. This has to happen at the date of disclosure. The report has to be written.
Yeah, and most times you want to have it done before then. But sometimes the situation it's is different, and if but in any event, we like to get ours. Like I said, we like to have them before the case is even filed, but in any event, well before the deadline.
Excellent. And then my question was, now what if some facts or new evidence during discovery is established, and an expert has to change what was in their initial report based on new evidence? There is a supplemental report that can be furnished later on, correct?
Yes, and the reason, this is pretty similar to state court as well. The reason that you have to supplement, because a lot of times by the expert disclosure date, you don't have all the evidence in. In other words, you might not have all the documents. You might not have all the depositions of parties and fact witnesses and other experts. So that's when the rule for the supplemental report comes in.
Okay.
That's like I said, that's done, and the same rules apply to that.
Excellent. Okay. And this all goes back to our standard, a judge can rule that there's a lot in the judge's discretion, correct? So a judge can rule that a report is not necessary, or that it can be turned over in a later date. I'm imagining if there's some sort of circumstance that prevents it from being submitted at the disclosure date, but it's not a risk you'd want to take.
Mm-hmm.
Is that right? Is it
That's
mostly
correct.
in the judge's discretion if something? Have you found many judges in the federal court? Have you ever not had to present one, Daryl, at the time of expert disclosure?
I have not.
Okay,
I have not. And,
good to know.
it's basically one or two specific judges that I work with, and it's just a given.
Okay.
And it's something, like I said, that if we don't have it before we file a case, we have it very soon afterward.
Okay. All right. So shall we move on?
Sure.
All right. So what is required to be in this report?
Okay. This is a lot of stuff. And I'm going to read from the PowerPoint: a complete statement of all the opinions that the witness will express and the basis and reasons for them. Because typically the first question you're going to get in deposition when the defense lawyer is deposing your expert is, what is your basis for that opinion?
Mm-hmm.
So that's got to be, right there at the top. And then the facts and data considered by the expert witness informing his or her opinions, any exhibits that will be used to summarize or support those. Sometimes those will appear more often in a supplement.
Okay.
If they're not available at the time, or the lawyer hasn't decided what exhibits he wants to really showcase at trial.
Okay.
And then here's a big one that's a little bit different than a lot of states, is the witness qualification.
Right.
You have to include a list of all publications authored in the previous 10 years. And
which is going to force the expert to go back and do some research if they haven't kept this up on their CV, correct?
Yes. Many are going to have these and update them regularly, but not always.
Okay.
And then you'll have to list the other cases that you have participated in during the previous 4 years. So 10 years on the publications, other cases for the past 4 years. This allows the opposing attorney to go back and try to dig up, because these are public records, and dig up old opinions to see if they're consistent, or at least the science and is consistent with their opinions that they've given in the past.
Okay. And that's interesting because a list of all other cases in which during the previous 4 years the witness testified as an expert at trial or by deposition, that's different than a lot of states as well. So this is something that most experts should be keeping up. Does this only include 4 years of, say, federal cases that they have testified in, or do they need to have the 4 years of state and federal?
Yeah, I think they have both, because I think that the federal rules are typically going to be more encompassing than any similar state rule. And in the state court, this is not near, especially in my state, is not near as important. But I think to be safe and to be within the rule, I always tell people on this particular rule in federal court, give more rather than less.
Okay. More than less. That's a good plan.
Mm-hmm.
And this also comes into it's always a question, the statement of compensation to be paid for any study or testimony in the case.
Yeah, that's another one that's not required in the state, in most states.
Most states.
That I can say with certainty.
Right. And you and I talked about this, not a time for predictions on costs, right? This is basically what the agreement is for billable hours, or what travel costs, things like that. What the expert's fee schedule basically says. Is that right?
Yeah, that's correct.
Okay.
Because you never know. I mean, if you go back and do, if there's depositions, and then if you do video deposition for trial, it can really be all over the map. So it's just more what their travel schedule is, what they charge per hour, and that, just so you understand, once you get to deposition, the opposing attorney, whether it be the defense or the plaintiff, is going to want to know what you're being paid for this testimony. And a lot of times when it's doctors, what percentage of their practice is depositions for plaintiff or defense lawyers, and what percentage of their practice is actually treating patients.
Okay. That's good to know. That oftentimes comes up when an attorney reaches out to us and asks us to find an expert for them. They're really interested. Is this person still practicing, or are they a full-time expert witness?
Sure, that's fair game.
Yeah, that's fair game. Good to know. Yeah, and I do want to apologize, folks. I know that you can see, somebody mentioned in the chat, you can see the slideshow on the left-hand side. There have been some changes to the platform since I last utilized it for this, and I'm having trouble getting it to full screen view for you, and we're also having some difficulty with Daryl's video. Those are usually things that I was able to just tap on and change, and I'll have it corrected for the next webinar. So apologize in advance for that. Daryl, shall I move on to the next slide?
Sure.
All right.
And I read through the chats, and I'm going to try to stay closer to the microphone, and I hope that helps.
Yeah, I'm hearing you clear, but it sounded like somebody else was having difficulty, but it sounds good to me on my end. So what if new facts change the expert's opinion in federal court? What do they do then?
Well, that's when we go back into the supplement.
Okay.
And that's what that's for. And this is going to happen. It's not something that, it's very likely to happen. It's going to happen more than it's going to happen less. Because, I can really only speak to contract cases and injury cases, but in injury cases, things change all the time. I know in one federal court we have pending, the plaintiff has died since we filed suit. So that, that's a new fact, obviously.
Right.
And, a doctor that's an expert on a case like that, or maybe even with the actual negligence, there's going to be changes to that situation, and those will have to be updated.
Okay. Yeah, I think one of the ones we had talked about were when in preparation for this was other conditions that have come on, say post accident, trucking accident, for example. At the initial stage, they had certain injuries, but now some additional conditions have presented themselves, and at that point, supplemental report may be necessary, explaining that this could or could not happen, depending on whether you're plaintiff or defense.
Yeah, and typically this is not, you don't really have to do the whole report over. It's just a lot of times it's a 1 or 2 page update.
Okay.
Sometimes just several paragraphs.
Okay.
And sometimes this is also good if you need to explain something further, the new facts. And like I said, that's going to happen, because there's going to be depositions taken after expert testimony. And like I said, it's always a more rather than less rule in federal court, because summary judgment standard is lower, and a good defense attorney or even a good plaintiff's attorney is going to move for summary judgment once these reports come in and new things are put on the table.
Okay. And and this report is really due before discovery has really taken place, correct? So there may be facts discovered during as discovery goes on.
It depends.
Okay.
Let's see, I can think of several cases right now where it's just due in the middle of discovery.
Okay.
Not necessarily and then I can think of one that we, the first thing we did was disclosing our expert witnesses before it's just the timing. We just didn't have all the witnesses, and now we're getting closer to trial, so it's more of a thing of taking some trial depositions and things like that.
Okay.
our federal judge is real. About the only thing that he's pretty lenient on is extending discovery dates for deposition.
Other than that, he runs a pretty tight ship as far as when things are due. Is that
Because in federal court there has to be diversity jurisdiction, and people are going to be spread out. It's not like they're all in one. They're going to be in other states and across the country and things like that. So he's a
right?
little bit lenient. I probably would say most are.
Okay, and just for for edification of our listeners here today, you practice you actually like practicing more and are practicing more in federal courts, and you do a lot of semi-truck accidents, pharmaceutical litigation, nursing home abuse litigation, those types of things. It's often in the federal court because those companies are oftentimes incorporated outside of Kentucky, where you're located. Is that why you're doing a lot more federal practice these days?
Absolutely, and a good, like I said, I'm 100% plaintiffs.
Mm-hmm.
And any good defense attorney, the first thing they're going to do when you file suit, because you're always going to, 99% of the time, we're filing in state court.
Okay.
In case we go federal, we get removed, and that's the first thing they look at. And any reason they can find to get you over a federal court, we don't sweat it as much because we feel like federal court judges are better about enforcing the rules.
Okay.
State courts are more lenient. They typically know the attorneys better, even in a social sense, not just seeing them in court or whatnot. And so they're a lot more lenient on dates and deadlines and stuff like that. But in federal court, I would urge the 100% literal compliance with the rules. And like we said earlier, this is the most important one.
Right. That's right. Okay. So, and you say if new facts, the slide here says new facts can cause you to change or alter your opinion. So you want to create and submit that supplemental report as soon as possible. The attorney's going to be telling the expert that, so the experts know they don't necessarily need to keep up with this, right? They're going to hear from the counsel with whom they're working that, hey, by the way, here's the new facts and we need a supplemental report.
Yes, that's correct.
Okay. And then state what facts or information you've used and what effect it has had on the conclusion. And I think you mentioned that you may submit a supplemental report, but the conclusion may not change. The conclusion of the expert may not change.
Yeah, the conclusion most of the time won't change, but the opinions can. So,
okay.
And this is not a general rule that every lawyer lives by, but I do, and I've had some success with it, is when we talk about expert testimony, we talk in terms of opinions. What opinions are they using? What is the basis for those opinions? What facts and data did they rely on? And I just think it's simple. When I first started practicing, I was so overwhelmed with the thought of experts and they having greater knowledge than I did.
Mm-hmm.
And they use so many different ones that it really just kind of overwhelms you.
Mm-hmm.
But if you think of it in terms of opinions, I think it really, really reduces your stress level and it really simplifies it, and even simplifies it for the jury.
Okay.
Which is the most important thing.
Excellent. I'm going to go ahead and move on to the next slide. I think have we done enough on the supplement there? Any other items you wanted to add?
Nothing I can think of, Nick.
All right. So then this is where we kind of get into the Rule 702, because they do go hand in hand, right? It's the Federal Rules of Civil Procedure 26 outline a lot of stuff for expert witnesses in the discovery stage, but then the evidence rules, Federal Rules of Evidence 702, I think 03 and 04 as well, which are essentially, we could have a webinar on just about every one of these rules, and we may be doing that in the near future because, as I mentioned, this is essentially an introduction. But we thought that some 702 was necessary here, right, Daryl? You almost have to touch on it when discussing 26.
I think you're correct in that, Nick. Like you said, they go hand in hand. This and Federal Rule 26 go hand in hand. And like you said, this is getting into the Dobbert stuff, and this is a whole webinar in itself. But we've decided to put it in today because it is so important. It is something that can kill your case, and it's something you've got to be very cognizant of at the start of a case or whenever you're putting together your expert report.
That's right, and I should caution. I know we've got a lot of folks here, and I should caution our experts that Dobbert, this Rule 702, basically codified Dobbert or Daubert, and you need to keep in mind most states follow this, but not all states. And in Florida, for one, is a recent one that, and Daryl, I realized that I was going to share an article with you on this because I know you're also licensed in Florida and Kentucky, and I forgot to do that. But essentially, Florida had adopted Dobbert recently, I think just last year, but then the Supreme Court sort of took them back to a Fry standard. And I'll if you want more information about this, email me after the webinar and I'll send it to you. So Florida is in sort of this in flux right now between Dobbert and Fry standards. Fry being the standard, the general acceptance rule was a big part of Fry. So make sure when you're working with your attorneys, especially when it's a state court, that you know which rule you're following. Most follow Rule 702 in Dobbert, but it's not entirely that way. So in the federal court, they do follow Rule 702, which is codified Dobbert. So tell us a little bit about this.
All right, this rule, again, this is this. I think it's important, and you pointed this out earlier. This is an evidentiary rule.
Right.
This is not, it's not what we've been talking about with the civil rule 26. And off the top, a witness is qualified as an expert by his or her knowledge or skill, experience, training, and education, and may testify in the form of an opinion or otherwise if that expert's scientific, technical, or otherwise special knowledge will help the trier of fact to understand the evidence or to determine a fact in issue.
Okay. And this should all be essentially in their CV, right? Doesn't that help qualify them at the 26 stage when they get disclosed?
Mm-hmm. Now, in deposition, the attorney will qualify them, but that's a good way to look at it. Is that's what they're, that's the purpose for their CV.
Okay.
To show that this person is qualified to be an expert in this subject, whatever subject that is.
So this could be policies and procedures for nursing homes, or It could be your, especially 702A here, could be your background as a emergency room physician, or if you're a pharmacologist, if it was a pharmaceutical litigation.
Correct.
Okay.
And the attorneys and the experts too, I think they need to realize in this, we can never be too careful as attorneys, that especially when we're bringing in doctors, that they're not trying to do everything. Because, for instance, a cardiologist is not qualified to testify to nursing home standards if they don't have any experience in that, or specialized knowledge in that field.
Right.
So, and a lot of times, when if it's a plaintiff's attorney or sometimes even defense, they're trying to get one expert to cover all, and they really can't do that.
Okay.
And you really risk. That's where I see Dobbert challenges winning. When you've got experts that have routinely testified in a certain area, the challenges are less and less.
Mm-hmm.
But this is the rule where they're going to try to, this is more of that backdoor summary judgment where they can, and it's not going to, this rule typically is not going to take out all your testimony, but it could get to things like causation. I guess it could get to things like damages. And, basically, if you lose causation on a case, basically they have disqualified your expert.
Right, right. And you made, so for example, you use the cardiologist who's testifying on a nursing home case, when
Correct.
maybe a nursing home medical director, it would be more appropriate for somebody with experience as a medical director, would be more appropriate.
Even a nursing home, a nursing
Right.
Qualified nurse.
Okay.
Really good at those situations.
All right. And then in B, it says the testimony is based on sufficient facts or data. Is this where they're getting it from, the literature reviews and scientific journals and things of that nature?
Yes.
Okay.
Yes. And I was trying to think of a good example for this one. And basically, we challenged a guy on the stand one time when he was an accident reconstructionist who was basically testifying with a lack of facts and data. And so he tried, what really caught it to our attention was he was testifying on something where the truck and the as funny as this is going to sound, and me being from Kentucky, I know you guys can probably believe it, but a semi truck hit a cow. And it has since been deemed in not only our court, but the Court of Appeals as the cow case. And he testified, basically a semi hitting a cow is like a car running over a beer can.
Okay.
So, and there were some other things in there. I don't remember every single detail, but he'd been called up last minute. There had been a change in attorneys, and this guy was really good. He was the best in the business at the time, but he just did not have the facts and data. He didn't have time to collect it. Evidence was missing. It was gone. And so I thought that might be a fun example for that one. Yeah,
that is a good one. And would testimony based on sufficient facts and data, would speculation fall into this? Like, well, we don't have facts that sufficient facts to lead to the speculation or the hypothetical that this expert is presenting. Is that possible as well?
Yeah, I like to stay away from speculation, but I do think hypotheticals are important.
Okay.
When there's a lack of, obviously you want the sufficient facts and data.
Right.
When you don't, a lot of times you do have to go with the hypotheticals.
Okay. All right. And then the testimony is the product of reliable principles and methods. Is that also going to be supported by, say, literature or scientific treatises, that type of thing?
Yes, and tests.
Tests.
Back in the law school, how often do we hear there's the test for this is this, the test for that.
That's right.
Even down to Dobbert, even down to Fry.
Yeah. Okay. So that's good to know. And if they're using, every once in a while, I'll see an article about this, and you've probably seen it as well. But every once in a while, an expert will be booted because they're using some really new sort of fringe, or what most of the time people will want to refer to, or reporters will refer to as junk science. It doesn't mean necessarily that it's junk. It's just that maybe it's not accepted by the courts as reliable methodology or scientific principles, at least not yet, because it has not been studied enough. Yeah,
I think we sometimes have trouble with, depending on which judge you have. In state court, I haven't ran across this in federal court, with getting chiropractic doctors' opinions in, because they can be challenged as not reliable.
Is not reliable. Okay, that's good to know. And I think our friend Guy DiMartino, who's also done a webinar with us, would challenge that, right? Because he's a lawyer and a chiropractor.
That's right.
Yeah, and the expert has reliably applied the principles and methods to the facts of the case. So this is This is, you've done your analysis. Now you're applying it to the facts that are presented.
Yes.
So the cow case one, you probably would have argued that his opinion was not reliably applied.
Yes, and we were able to limit that opinion.
Okay.
It was a crazy case. It was kind of all over the map, but we were able to limit his opinion.
Okay. All right.
Because of his lack of information and getting it on the tape. Like I said, you could not attack that particular expert on his qualifications because he was the best.
Uh-huh.
It was well known by judges, lawyers, defense plaintiff, and I even told my partner, we'll never try another case without this guy.
Interesting.
Yeah, but his qualifications were off the chart. His opinions on that particular, it was more what we were talking speculation, and that word just scares me. That's why I like to talk in terms of opinions, even in hypotheticals. When you get to speculation, it's not a good word in court.
Right. Okay. Good to know. Good to know. And so we have our last slide here, and then we'll jump into some questions for you. A little last stuff on 702. Anything that you it is the standard, as we mentioned, for expert testimony in the federal courts. It is the standard in many courts. One of our attendees has mentioned that it is the standard in New Jersey. And you say all expert testimony must conform to these rules. Do you get in debates with opposing counsel over, say, 702 A, B, C, or D? Have you had disputes over each of those, or is there one that you see more than others?
Yeah, in federal court, not so much, because
Okay.
I don't think a defense attorney, in my situation, is going to try to put someone in without qualifications. So I don't think that's going to happen.
Okay.
But you do see that in state court
Okay.
a lot, and especially if it's if someone looking to limit expense, someone that's maybe not as the lawyer's not as qualified, then you might see them trying to operate on the cheap and not going out and getting the best guys.
Right.
And I've been there before. I understand what it's like to try a case, with limited resources, let's say.
Right.
So, and I'm trying to answer a question that I got.
Yeah. We got a couple, and we're at that point now, folks. So if you want to post,
okay. I'm not going to try to type them. I'll answer them as you ask them to.
Yeah. If you want to post some questions in the Q&A section, it'll be easier for us to pull them up rather than the chat. But Lloyd has asked, Daryl, do you prefer to see exhibits in the body of the report itself, or in a supplement, or both?
Lloyd, thanks for that question. And I was trying to type an answer to that, but I didn't quite get it done. That's a good question. And I think from my training as a lawyer, we always put exhibits at the end of stuff. If we're answering interrogatory questions, whatever. So I really don't think it matters which you do. But as for us, my office, we do put exhibits at the end and put them as exhibit A, B, C, D, E, F. And we also, as lawyers, we always see exhibits at the end of deposition. So I don't think there's anything wrong with putting it in the body of a supplement. But like I said, just our training and the way we've always done things and seen things done is the reason we do that. That's a good question.
It is, and Lloyd has a couple of follow-up questions here on 702C, and I'm going to go back to that slide so folks can see that. He's asking, how much latitude is reasonable regarding specific methods? So the reliable principles and methods section. And he gives an example. In accounting, principles are relatively static until they change. So while methods often vary depending on an expert's experience and facts and circumstances of the case. So he's wondering how much latitude on the specific methods. Have you had any experience with difficulty is in this section?
Well, the answer for me is going to be, it's going to depend on which judge and which court it's in. For instance, I think there's going to be less room for latitude when you're in front of a federal district court judge than there is, say, in your own state court. You're going to have a wider range of latitude. And then, when I work in these CLEs where there's defense attorneys there as well, I always tell them, I feel like there's more latitude for a defendant than there is for a plaintiff's lawyer. So I think that's just based on experience. Is the way I was taught, that there will be more latitude on the other side.
Okay.
And again, federal court summary judgment standard is easier, and so I would say it's just going to depend on your judge. And I know that's not as good an answer as I'd like to give, but that's just kind of what I've learned the hard way.
It's just what we always hear with the law, right? It depends.
Mm-hmm.
It really depends. And let's see. The slides will be actually the video. We have a question from Margot about she may have missed this. The slides be available. We can make them available, but the video is actually going to be sent to you with the slides in it. So you should have that, Margot. Lloyd asks another question, and folks, I don't see anything coming in the Q&A. So if you're having difficulty finding the Q&A section and you'd like to ask Daryl some questions, go ahead. Let's see. I see a raised hand here. I know that JDSA Fire had a question. Can you post it in the chat, JDSA? That would be helpful. And until I get that chat from JDSA Fire, I'm going to say Lloyd's next question: when facts are lacking, do you prefer hypotheticals or reasoned and reasonable assumptions? And for mine, do you differentiate from there?
Oh, is that a question for me, Nick?
Yeah.
Okay. I was going through the chat, making sure we didn't miss anything.
Yeah, Lloyd asked, when facts are lacking, do you prefer hypotheticals or reasoned and reasonable assumptions? Do you I
definitely, without a doubt, prefer hypotheticals, and the reason I'm of that opinion is it's easier for a lawyer on his feet to come up with a hypothetical. As I said, the whole speculation is the thing that scares me the most. That word speculation, just, if we're talking about trial, it really sends chills up my spine.
Right.
So, but I think, the other thing about the hypotheticals is hypotheticals and analogies help the trier of fact, the jury. And, not a day goes by that we don't look for another hypothetical or another analogy to be able to explain something. And so I think as expert witnesses, if you could think in terms of hypotheticals, if you could think in terms of analogies, that's going to be clearer to the jury. It's going to be easier for them to understand, and it's going to be, a lot better evidence for your, for your client, the side you're testifying for.
Right. Very good. I see hands going up, folks. Again, I apologize. The new setup here, I can't seem to click on the hand that's coming up and be able to ask you to answer. So if you could, in the chat, somebody else said the Q&A doesn't seem to be working. So go ahead and go with the chat. Daryl and I are used to this. We participate in a Legal Minds group where we're often on camera and in the chat at the same time. John asks, I know this is very basic, but will you please specifically define publications? That's a good question. That is a good question. Yeah. Can you tell us a little bit about that, Daryl?
I think publications, again, being the more rather than less rule that we try to practice by, that you want to put anything that could possibly be defined as a publication. If it's a white paper, if it's a short article, if it's a blog. I know if you get into blogs and white papers, it may get a little extensive, but I still think you're better putting more rather than less, because I know, when I go through your publications and then I take your deposition, I'm going to start asking you about some of those, and you're probably going to get ask about the ones that you didn't listen, because lawyers on both sides of the fence, defense and plaintiffs, we talk back and forth to each other about expert witnesses, and we're always looking for something that they didn't disclose, that they didn't. So I would use that general more rather than less, and especially 10 times as much in federal court.
Okay. Excellent. And from JDSA Fire, who was having difficulty finding the Q&A, the comment is for
Hey,
Rule
Nick,
20. Yeah.
I want to add something else. I think he put something up that would be burdensome, and I wholeheartedly agree. If you're getting into everything that is burdensome,
Yeah.
I think you can get away with saying, my name is so and so, Daryl T. Dixon, and I have a blog, and so maybe your publication is Daryl T. Dixon Law Blog.
Okay.
And you don't have to go through there and give every single article. So there are ways you can make it less burdensome and still be, with that more rather than less.
Cool. Excellent. And to JDSA Fire's comment, for Rule 26, where an expert must write and sign a report, warning that some attorneys will want to write part or all of the report. This is not good for an expert. This sounds like an experience that JDSA Fire has had. Have you ever heard of this, Daryl, where an attorney wants to write the report on behalf of the expert and have the expert sign it?
I have never tried to do that, and I wouldn't try to do that, because come deposition time, the talent you have on the other side now, on the defense side, they're going, if that's the case, they're going to find it. And I think somebody asked, does publication include expert reports? In that, I would say no.
No. Okay.
Because those are for that particular case, and that's attorney-client work product.
Okay. And
but yeah,
go ahead.
I would say it's a big no to have a lawyer writing the expert report for you, because, like I said, the talent you have on the other side now, they're going to uncover that.
Right.
And once they uncover it, it's probably coming in.
Right. And then from Ken, we have a question as to, can you clarify what you mean by hypothetical? If no evidence is found that someone fulfilled a certain role, can you assume they did not? Or what do you mean by hypothetical?
I look at hypothetical. That's a really good question, because that opinion or that answer is going to differ if it's a lawyer or if it's an expert. As a lawyer, I try to ask hypothetical questions. I think the one we talked about in the cow case is the expert saying it was, a semi hitting a cow is like a car driving over a beer can.
Mm-hmm.
And so he's giving a hypothetical, an example, a hypothetical. But I use hypothetical questions all the time. And even, on my direct and my cross examination of the defense expert.
Okay.
So that's why I prefer those. And if you, like I said, if you want to simplify them even more, think of them as analogies.
Right.
And if you think of them as analogies, you think of it's like, and I don't have any specific ones coming to my head right now, but when you can explain a situation and say it's like, I think that's the best way to do it.
Okay. All right. And then we have from Alan. He considers himself an expert in his overall field, but a generalist within that field. So when asked if he's an expert on a particular narrow topic in the field, he has been hesitant to say yes, because he knows there are people out there who know more on that narrow topic. Therefore, he said, I'm not an expert during deposition on that narrow topic.
Okay.
Plaintiff's attorneys have faulted him for this, saying that he is an expert, even if he knows that others know more than he does. Are there
Well,
any thoughts on that?
I think I can answer that one for him.
Okay.
We are taught in our ethics class and throughout preparation for the bar exam and all the way down the line, that the lawyer's definition of expert is different than what an expert's definition of an expert. So to meet the minimum standards of being an expert for a lawyer in a particular category, they always say if it's something that you can research and educate yourself on, take CLEs, do online courses, if it's something that you can basically teach yourself so that you get up to a certain standard, then yes, you can consider yourself an expert.
Mm-hmm.
So I think you could probably use the same definition, the same process for experts.
You're essentially talking about becoming competent on the topic. Is that right?
Uh-huh.
Okay.
And so I think you got to use your best judgment there. But and if it's something you just don't feel comfortable with, then I would say no, I'm not qualified in that area. And because there's always going to be the next case and the next case where you are qualified in that area and you have the training and experience. But if it's something that you can teach yourself and get to that competency, then I think you can go ahead and do it. Tough call.
Yeah, that is a tough call. And our last question, and then we're going to wrap up, folks. You've got our contact information here. We have a question from Craig. And Craig, these questions may be part of the next series of webinars or future series of webinars, because we really didn't get into the discoverability, which is a big portion here of Rule 26, which is the scope of what's discoverable. But he said, can you explain what information is not discoverable if an expert is asked to produce his or her file for deposition purposes? It is. Are you there, Daryl?
Yeah, I am, and
Yeah.
I'm just kind of thinking. That's a good question. It's it's one that I've had many expert witnesses tell me. I've also had expert witnesses tell me what was discoverable and what wasn't. So I think it's something that you have to go. It just needs to be an open dialogue between you and your counsel. I don't think I think we talked earlier about specific reports from other cases. I do not think that is discoverable, but I think that anything you have used to form an opinion in this particular case, I think you must turn that over to them. And I'll say first, most of the time, the defense lawyers I go against, they don't so much as care what you have in it. They just want to see if you're going to produce it. But then again, I've seen ones who will spend, forever and a day looking at it, analyzing every single thing. So I would say when in doubt, again, go with the more rather than less. You never have to disclose anything that was part of a different case. But if it factored into your opinion in that particular case, then I think you owe it to them to have it in that file.
Excellent. And John said it was a great answer on the expert definition of lawyers versus experts. They really appreciated that competency definition. Craig asks one last question. This will be our last question, folks, and we'll have replay out to you within a couple of days. And feel free to reach out to me if you have questions or you want that article from Florida. How should we, and Craig's last question, how should we handle a situation where a law firm client wants one to serve a dual role as both an engineering and a human factors expert, where one really is only qualified in the engineering field? and I've seen this too. Not uncommon for attorneys to want to use one expert to serve two purposes.
Sure.
And he asks, is that due to financial constraints? Which, in my experience, it has almost always been related to financial constraints. But what would you tell an expert in this?
Again, I'd say probably go back to what we talked about with competency. I wouldn't. If you don't feel comfortable, I wouldn't do it. And again, I think we talked about this a little bit earlier, but if you're trying to use an expert for more than one situation within one case, a lot of times it's because that attorney is having trouble financing that case.
Mm-hmm.
And I totally understand. I empathize with them because I've been there before, and that has been me. And I have tried to use them for things. Typically, once they tell me they're not comfortable, I move on. I don't insist that they come up with something. But if you're wanting to, if you feel uncomfortable, I would just tell the attorney no. If you want to do it, and most of us want to help when we can,
mm-hmm.
Then I think you go back to the test of getting competent. Is there some training you can do? Is there some classes, some courses? You know, we got so much at our disposal anymore that you can get caught up in any area.
Mm-hmm.
Now I feel like a couple of years ago I didn't know what a brain injury was,
Right.
And now I feel like, you know, after a couple of years of study, and I'm not saying you're always going to have a couple of years, because you're not.
Right.
But after a couple of years of study, I feel like I'm an expert in brain injury cases, and so.
And the science in that has changed rapidly in the last few years too.
Sure.
So
And it's going to continue to change.
Right.
And I think when we had a question about methods and everything, you know, one thing we're going through right now in brain injury cases is that plaintiffs' doctors are using updated MRI machines, you know, 3T MRI, 3 Tesla MRIs. And a lot of times defense is using a 1.5 Tesla, which is a much weaker strength. And so we're trying to use the new technology. And as a member of the plaintiffs' bar, we try to go in and throughout the case show that, hey, plaintiff, we're trying to get you all the information, and we're even using the updated technology.
Right.
The defense is wanting to lean on old ways that basically disguises information, and
Right.
they're not getting you the latest breaking stuff. And you know, get a lot of that stuff from Nick. You know, he leads the way in this technological revolution that we're under right now. So, and I learn stuff from him all the time.
And vice versa. I appreciate your time, Daryl. Yeah.
Can I say one more thing? There
Please.
Was a question that I went through here. It said, and I think it said, what is the best way to bill your expert? If you guys haven't done it, I would get set up on credit card machines. Most attorneys that I know are like myself, even defense attorneys.
Mm-hmm.
And we like the credit card points because a lot of times we're having to fly halfway around the country to see you guys.
Mm-hmm.
And so any money we spend with you, we would, you know, if it's a $10,000 expert fee, then that's almost a flight one way
Right.
for a deposition or whatnot. So, and most attorneys, I can't speak for everybody, most of them will be happy to pay the 3% or whatever it costs for the credit card. So
just because of convenience
and the miles.
Right.
And the travel, and then we can cut those costs for our clients.
Yeah, I mean, just in the last 6 weeks, you've been out from Kentucky. He's been out in our neck of the woods at least twice in the last 6 weeks.
Mm-hmm.
So.
Going again in April.
Going again in next month. So,
yeah.
All right, everybody. Daryl, thank you so much for taking the time. They had a great crew today. Appreciate everybody sticking around in all the good questions. Daryl, thanks again so much. Daryl,
I had a blast.
No, I did too. I always enjoy hanging out with you when I get a chance. So appreciate it very much, everybody. Stay tuned. We'll send out the video to you, the replay, and we'll let you know when the next webinar is happening. Thanks again, all.